evening, everyone. My name is Yanetta Emanuel, Interim Public Policy Director here at the ACLU of Maryland, and thank you for joining us this evening for an update and an overview of the Maryland Coalition for Justice and Police Accountability's priorities for the 22 legislative session. So first, we're gonna be hearing from Davon Love, Director of Public Policy with Leaders of Beautiful Struggle, and Tiara Hawks, Chair of the Baltimore Civilian Review Board, about our bill this session to give the Civilian Review Board in Baltimore City the powers and responsibilities of the Police Accountability Board. So I'll go ahead and turn it over to you, Davon.
All right, thanks, Jeanette. Good evening, everybody. Again, my name is Davon Love, Director of Public Policy, Leaders of a Beautiful Struggle. One of the things that I want to do before I jump into what the bill actually does is just to give some context. As many people will be aware, or should be aware, that last session there was a variety of police accountability legislation that passed the Maryland General Assembly. One among them, HB 670, is a bill that dealt with discipline, because one of the biggest issues that has emerged as a result of the major uprisings over the past several years is the issue of officers' inability to be disciplined for engaging in misconduct, particularly against Black people. And so one of the things that was included in HB 670 is a part of a pretty significant shift in the nature of how discipline is structured within law enforcement, are the creation of police accountability boards. And just before I get into that, it's going to be very important that this year is a year of implementation. So there are lots of really complex and important aspects of HB 670. And every jurisdiction, I think, is going to need to make sure that they're paying attention to all the different moving parts, just to make sure that the positive elements of HB 670 are working at its optimal level. So one of the aspects of HB 670 is it requires each jurisdiction to establish a police accountability board. These are in the larger disciplinary matrix, the container by which community is able to provide or to give complaints about law enforcement. The police accountability boards also appoint 3 of the 5 members of the administrative charging committee. This charging committee is responsible for essentially, when internal affairs provides their investigation, that it is to essentially rule on an investigation as to what is the action that is taken, whether it's discipline, whether the person is not administratively charged. And so this charging committee is important. And the police accountability board, again, gets to appoint 3 of the 5 members of those administrative charging committees. So the police accountability board, what comes with it is significant power, again, in the larger scheme of the new disciplinary matrix. One of the things that has happened, we believe, as a genuine oversight of leadership in producing HB 670, is the fact that Baltimore City has an existing oversight structure, the Civilian Review Board, that was created in 1999 as a result of a grassroots push around the issue of community oversight of law enforcement. And so the police accountability boards and the responsibilities and powers that it's designated with it, and the powers and responsibilities with the Civilian Review Board, that they are duplicative, right? And having 2 of these entities existing at the same time in Baltimore City would be confusing, would be administratively wasteful and inefficient. And so what we are putting forward is a bill that would essentially give the powers and responsibilities of the Police Accountability Board to the Civilian Review Board in order to have an efficient way of living up to the mandate of the establishment of the police accountability boards, without creating an entirely new infrastructure, an entirely new process, and undermining much of the progress and work that's been done by the Civilian Review Board, particularly over the past several years, as they've been renewed and increased energy and attention put to it. So that's what it does. So what I want to do now is invite Tiara Hawks who is the chair of the Baltimore Civilian Review Board, to talk about the work that the CRB has done and why the CRB supports this bill.
Thank you, Davon. The CRB is the only entity in Baltimore City currently right now that can investigate complaints of police misconduct. We are a safe and neutral place where citizens can file complaints and we investigate them and hear them. And we issue disciplinary recommendations. We base those recommendations off of our own investigatory reports that are submitted, our training, our knowledge, and just common sense, to be honest. The board has 9 members from each district of Baltimore City when we have a full board, and we also have non-voting members from the ACLU, the NAACP, and Fraternal Order of the Police. Our current board has a variety of individuals who have different career paths. We have lawyers, psychologists, mathematicians, nurses, school counselors, all different types of people from all different walks of life. So their experiences with police are different, and our knowledges and what we bring to the table is when we're thinking about disciplinary recommendations are different. There are 5 categories of complaints that we hear currently. They include excessive force, harassment, abusive language, false arrest, and false imprisonment. Last year alone during the pandemic, we received 117 complaints through the phone. We issued 49 recommendations and we held 60 investigations. I think that's a lot of work as far as police accountability and transparency is concerned, especially during the pandemic year when you would think, people have been in the house, there's been limited interactions and things like that. You wouldn't expect those types of numbers as far as police misconduct is concerned. The CRB is in the policing business, and we're striving to reach that level of police transparency and accountability when it comes to disciplinary recommendations. We have been challenged and we're often ridiculed by the work that we do because of the limited resources and powers that we have under our current legislation. And until something different happens, I don't think that the CRB can be faulted for having those types of limitations. With the support of this bill, the CRB would be empowered. We'd be able to complete the task of the PAB and whatever other authority that you all can give to us. We know this because we've been doing it. We're under the consent decree. We're a partner in the consent decree. And we were established to do just this. With the broader category of complaints, we would be able to hear abusive language and neglect cases and things like that, where we currently hear the cases and we're unable to do anything about them. So the CRB should be strengthened. It would strengthen community oversight and awareness as a whole. The CRB, we know, lacks funding. We lack a fancy data system. We need outreach workers. We need things. And based on those things that we've been ridiculed about, with the help of this legislation, we'd be able to access some of those things. Expanding the CRB scope and review will allow the CRB to include the PAB responsibilities, the duties to investigate and review additional claims against officers and things like that. But, due to our limitations, we still feel we have a strong infrastructure of systems and people involved who know what they're doing. As I said before, we're in the policing business. So the CRB is able and is willing to expand our roles and responsibilities if this bill is passed.
Thank you so much for that. And before we move on to our next speaker, just want to share that the bill does have a bill number now. It's SB 441, and the hearing will be on February 16th at 1 p.m. in the Senate Judicial Proceedings Committee. So those who are interested in supporting this bill, I encourage you all to reach out to your legislator and urge them to support this bill as well. If you're interested in testifying in support of the bill, the hearing is on the 16th and testimony will be due at least 24 hours before the hearing. And additionally, if you'd like to find our one-pager or any talking points or a toolkit, those are all available on our coalition website, which is mcjpa.org. And again, that's mcjpa.org. And so next, I'm going to turn over to our senior policy analyst at the ACLU of Maryland, Justin Nally, to give us an update on efforts to shift funding from school resource officers into more supports and services for students. And so, Justin, I'll turn over to you.
Thank you. Excuse me. Thank you, Yannette. Good evening, everyone. This is Justin Alley with the ACLU. I want to speak tonight about our children in Maryland and the crisis that we see within our public schools. So what we've seen within our public schools is the overcriminalization of students, especially Black students and students with disabilities. Students enter the school to prison pipeline for a myriad of reasons. So as a coalition, we've taken a multi-pronged approach to address this issue to continue to protect our students within public schools. Our first approach is decriminalizing offenses. So Maryland law allows students to be charged for disturbing or disrupting school, meaning a kid being a kid in the classroom in the hallways could be a criminal offense. In fiscal year 2019, the Maryland Department of Juvenile Services received 1,700 referrals for young people charged with disturbing school activities or personnel. The law is so broad that youth can currently be charged for a crime with behaviors that should be handled within the school disciplinary process. This includes talking back, refusing to follow directions, or making impulsive statements that is not associated with any harm to anybody in the school. We know that this code should be removed from state law altogether. What we've been supporting is a bill, HB 84 and Senate Bill 119, which will remove this law from the books so that these situations of disruption can be handled through the school's regular behavior management processes and restorative approaches. The next pathway to protecting our students is through the reportable offenses law. Currently, Maryland law requires police to report to schools when a student is arrested in the community for one of over 50 offenses. So in Maryland, a simple arrest triggers a report to a student's school, whereas though in most states, a report is only triggered later in the juvenile legal process. Over 60% of these arrests are resolved before any petition is even filed in court. What we've been supporting is HB 146, which would significantly limit the offenses that can be reported to only crimes of violence and for offenses for which youth are charged as adults. The bill will also define what a reportable offense is as something that only occurs off school property. And it also directs school systems to follow existing school discipline procedures. And lastly, our last path of ensuring that our safety for our students is protected is shifting school resource funding of the $10 million SRO fund to more student supports. This includes mental health services, wraparound supports, restorative approaches, so that districts can hire counselors, social workers, school psychologists, restorative approaches practitioners, community school coordinators, and implement trauma-informed practices. In Maryland, the data is startling. Black students receive 56% of school-based arrests statewide, but only represent 1/3 of the student population. So this would lead you to think that Black students misbehave at a higher rate, which is completely false. The Safe to Learn Act of 2018 requires that schools have some sort of law enforcement coverage plan for each school district. So districts, what they've done is contracted with police departments to have school resource officers stationed within schools. So we know that police actually cause more harm for students, and police relationships look different based upon what those students look like. So what we've been working on is this bill that would transfer this funding. Now, this bill has a lot of pushback. There are issues within the state where we've seen kids having guns in schools or parents just feeling unsafe and not wanting to remove school resource officers. So we are continuously trying to educate and push the legislature to understand the breadth of this issue. There was a public briefing this morning in the Ways and Means Committee where our partners from the Public Justice Center and the Office of the Public Defender briefed the Ways and Means Committee on the harm that school resource officers cause. There will also be a briefing within the Senate Education, Health and Environmental Affairs Committee for them to have the same briefing. We are still pushing for legislators to file this bill that will change the state funding. And we're hopeful that with this multi-pronged approach at all these different levels, with decriminalizing student offenses, ensuring that reporting doesn't occur less things happen off of school grounds, and also removing the funds, we can move forward to really stemming this school to prison pipeline and protect our students in Maryland.
Thank you for that, Justin. So now next we'll move on and talk about Kwamna's law, and I'm going to bring up Miss Melody Cooper to share with us who Kwamna was, and we'll go over exactly why this bill is important.
Good afternoon. I am the mother of now deceased Kwamna Akron, and I believe that this bill is important for everyone of color because my son Kwamna was murdered by Gaithersburg City police officers on January 8th of last year. And to this day, we still don't know exactly what happened to my son because they were not wearing body cameras. We do know that he was shot in his back several times and then turned over and continued shot while he was already deceased. And it's very important that this bill be passed so that we don't have a lot of other victims and families going through what I'm still going through with the loss of my child, which was, he was only 24, a very vibrant young man. He had his whole life in front of him just to have it snatched away by Gaithersburg plainclothes officers that did not follow protocol and procedures. And I believe they thought they didn't have to because they didn't wear body cameras, so no one would know what they were doing, and they could collaborate a story to make it look like my son actually did something to provoke them to shoot him. When they tried to proclaim that he shot at them, there was a gun, allegedly his, next to his hand, which was tested by their laboratory that stated the gun was inoperable. They put several clips in it to try to make the gun work. They were able to shoot one clip in March, and they went back and tested it again in May with a few more clips, and it never was able to operate. So these are the lies that these undercover officers, plainclothes officers, that they continue to collaborate stories while they're out there committing crimes because it's not being recorded. So it's very important for this bill to be passed for the sake of the community.
Thank you, Ms. Cooper. So this session, Delegate Leslie Lopez will be introducing a bill, which is HB 429. It does not have a hearing yet, but essentially what this bill will do is it seeks to fill in the missing pieces in our statewide body-worn camera policy that leaves too many police and civilian interactions unrecorded. So currently the law requires that all on-duty police officers wear body-worn cameras when interacting with the public, including plainclothes officers, although some departments interpret that differently. And what this bill does is it expands the requirement and makes it clear that one, municipal officers are required to wear body-worn cameras, but also that it's clear that plainclothes officers in every department are required to wear body-worn cameras as well. Additionally, the law will require that off-duty officers wear body-worn cameras when they're in public carrying their service weapon, whether working a secondary employment or going to the grocery store. And so that's pretty much the kind of the summary of what this bill does. It doesn't have a hearing yet, but again, you can find the one pager and toolkit will soon be uploaded all on our website, and that's at mcjpa.org. And that, I think, concludes us of our briefing today.